Hello, I'm Franklin Evans at post-Caxton era. This session is about student loans and is only a small part of my report into English education called 21st Century Education in the Post-Caxton Digital Era. You'll find a full script of this session on my website with links to relevant content. At the end you will see 14 areas which individually or combined make the student declaration a simple application form and not a contract. The student loan company fails to warn students that the total loan repayment could be about twice the initial loan due to added compound interest. To say English student loan contracts are not legally binding is a bold statement to make. It is my opinion gained from using the law and small claims courts for such things as Sale of Goods Act, unfair dismissal, redundancy, breach of contracts and parking tickets. I also taught consumer law in the sixth form GMVQ marketing course. I want to show you why I think the loan contract is flawed by breaking it down into individual pieces. In doing so, I hope you will learn something about our consumer laws. There are many good websites and forums that can help you to understand. A contract must state which laws are applicable. In this case, English. English laws cover a wide range of subjects, so we have to determine which are applicable to this student loan contract. Primarily, contract law and unfair terms in consumer contract regulations. As this is a financial transaction, you would naturally assume that it is governed by the Financial Conduct Authority regulations, FCA. Purposely hidden in the FCA regulations are clausing exempting student loans. More of this later. Why should you learn about contract law? You'll be surprised to find you're using it every day. You want to buy this product for £300. You take the product to the cashier, they take your money, a contract has been formed. You go online and buy the product, which looks very cheap. Your money is accepted, forming a contract. The company contacts you later saying there was an error with the price and they are cancelling your order. This would be a breach of contract if done without your agreement, and you can sue. This situation is not common, but is an interesting point of law. You take the item to the cashier and they say, "Sorry, but this product has been mispriced. It should be £350. There's nothing you can do about it in law. You have to pay the £350 or walk away. Why? The price on the product is not an offer, but an advertisement. In law, it is called invitation to treat, which is asking the shopper to make an offer which the shopkeeper can accept or refuse. So remember, when you try to swap price tickets over, don't be surprised when they tell you to. You know what I mean. We now have to determine what type of contract the student is signing. A. Declaration, a formal statement of facts. B. An application, which is a formal request to the loan company who then makes an offer. C. An invitation to treat by the loan company asking the student to make an offer. D. A binding contract. A declaration and application are similar and both are not contracts. They simply provide the loan company with sufficient information to offer the student a loan. The document has been titled Student Declaration in bold at the top of the form. 1. The contract is unenforceable as it is a simple statement of facts. The document uses the term declaration and contract in various places. A contract can use terms having different meanings and implications without explanation in the document. Defining the legal status of a document is a primary issue and cannot be ambiguous. 2. This contract is unenforceable due to the uncertainty of terms. In terms E, once the student signs the declaration, they are offering to form a contract with the loan company, even though they have no knowledge of the value of the loan or the interest. The loan company is saying that by signing the declaration the student has formed a binding irrevocable contract. Term E may be regarded as unfair. The regulation says irrevocably binding the consumer to terms with which he has no real opportunity of becoming acquainted before the conclusion of the contract. Unfair terms in Consumer Contract Regulations 1999, Schedule 2, 1I. 3. The contract contains unfair terms. Now let us look at the first two fundamental loan contract terms, A and B, in the declaration. Term A is telling the student to go to a website to read and understand the guides to the terms and contracts, the T's and C's. This is an unfair term as it discriminates against those who have no computer. The web link does not contain T's and C's, only another link. The guide to T's and C's is what it says, a guide too, not the actual T's and C's to be specified in the contract. The loan information actually is found in 3 different websites. Very confusing. To be a contract, all terms and conditions must be fully expressed in writing and cannot be implied by referring to other documents. All relevant T's and C's must be physically attached to the contract. 4. The contract is void as fundamental terms are not physically attached. The second of the 2 fundamental terms is B. Do you understand what is being said or implied by terms B? Is it reasonable for an average 18-year-old to have to pay legal fees for advice to explain these terms? The student loan company has the opportunity to fully explain terms A and B in the guide notes, but chose not to. 5. The contract is void as it is unintelligible to the students. What do these words actually mean? It refers to the fact that all the fees, interest rates, threshold values and termination dates can be altered by the Secretary of State at will without consultation or approval. This is an extract of the Act, Section 22(3), referring to a. Compound interest rates and threshold values, repayments and circumstances when repayments are not required or cancelled, bankruptcy only delays payment but does not cancel it, death cancels debt. It implies that all terms can be changed as may be prescribed from time to time. This is an unfair term under Schedule 2(1)(k), enabling the seller or supplier to alter unilaterally without a valid reason any characteristics of the product or service to be provided. 6. Terms B are unfair. Terms A has values found in the guidance note with specified interest rates, thresholds, amounts, with loan termination dates. The terms are fixed. And terms B states all terms can be changed as may be prescribed from time to time, without agreement by the student. These terms are variable. 7. The contract is unenforceable as terms B negate terms A. Act Section 22(5) refers to the recovery of loan amounts due. These innocuous few words in the Act are fundamental to this loan, as it forces the employer to remove loans directly from the student's salary and pay the taxman. The student loan is a primary loan and will be paid before any others. The FCA are now saying that student loans must be taken into account in the application for other types of loans and mortgages. The implication of Section 22(5) has not been highlighted to the student before signing the declaration. Now Section 23 of Terms B, the Secretary of State can sell this loan to debt management company. This is an unfair term. Schedule 2(1)(p), giving the seller or supplier the possibility of transferring his rights and obligations under the contract, where this may serve to reduce the guarantees for the consumer without the latter's agreement. These contract terms are designed to facilitate the sell-off. The government is already selling off their student loans but will not say for how much. 20p in the pound has been suggested. What happens to the other 80p? Can it just disappear? Signing the contract. The contract is not complete until both parties have read and agreed the same document. It is formed when the student and an individual legally representing the loan company sign the same document. 10. The contract is void as both parties must sign the same document. The contract must be voluntary. The government, schools, colleges, parents and society are collectively pressurizing pupils to go to university. Agree will get you more money. Students must have rite of passage into adulthood. Taking out a student loan is the only way students can go to university. Very few will have the ability to pay the cash or find alternative methods. This loan has profound consequences for students' future well-being. It is similar to the PPI scandal. 11. The contract is void as it is not voluntary. Breach of contract. The student loan company is a registered company with all the liabilities that it infers. Under English contract law, the contract binds both parties and neither can make changes. If they make changes to the contract without agreement, the student has the legal right to repudiate the contract, i.e. cancel it. At the very beginning, I said that the student loan contract is exempt from Financial Conduct Authority regulations. These are wide-ranging regulations designed to protect consumers from financial irregularities. The effect of not complying with these regulations means the student loan company does not need to supply financial information about the validity and the implications of the loan. This information is crucial for the student to make an informed decision. The student loan company has failed to mention the fundamental fact that the students have no legal protection given by the Financial Conduct Authority. 12. The contract is void as it admits that the FCA regulations do not apply. Even though it chose to ignore FCA regulations, the loan company still has to comply with the elements as are inherent in English contract law. A. Clear and fair and not misleading information. B. Uses plain, intelligible language. C. Balanced and emphasizing potential benefits. D. Fair and prominent indications of risk. The risk element in this loan is vitally important. 13. The contract is void as real and potential financial risks are withheld. 14. The contract is unenforceable as it shows no economic value. Now to look at the financial information that should have been supplied by the student loan company. This would allow students to see the total loan value over the full period. Data was taken from the guide notes set out repayments, interest rates in various situations, the lower and upper threshold levels and termination dates. When I first looked at this problem in March 2015, I wrote a spreadsheet using the variables to see what would happen. The only complication was that variable interest rates between the two thresholds meant changing each spreadsheet individually. One point that immediately strikes you is why is the interest rate maximum for the first 3 years at university when no money is being repaid? They cannot be trying to recover their admin costs. It looks perverse. Our current student loan scheme is running into problems as the number of students at or below the current lower threshold is increasing, so reducing the amount of the loan repayments. It is highly likely that the 9% repayment term will be increased to 12%, as has happened in New Zealand where they're having the same problems. It is also doubtful if the threshold values will be increased in line with inflation and the 30-year period not extended to 35 years. As the loans will be sold off to debt management companies, it makes this more likely to happen to increase saleability. 14 areas which individually or combined make the student declaration a simple application form and not a contract. Contract is unenforceable as a simple statement of facts, requires certainty of terms, terms B negate terms A, shows no economic value, called the consideration. The contract is void as fundamental terms are not physically attached, unintelligible to the students, fundamental terms being withheld from the student, both parties must sign the same document, not voluntary, vital regulatory terms have been withheld, real and potential risks withheld. There are 4 areas which could contain unfair terms. As a point of interest, the student loan company knowingly sells loans to students have no means of repaying the loan, and the contract is not voluntary. This loan is a combination of subprime mortgage and PPI scandals. My report into education comes from 20 years teaching all the techie subjects after 20 years in industrial design, engineering and marketing. I'll be interested in comments about my educational goals and proposed education knowledge management system. The contents page highlights many areas our educationalists ignore, posing many questions. Thank you for listening. Please use my contact page on my website to add comments. They will be posted as I find comments are often better than the article and widen the debate. Goodbye.